Now, change is coming the way of businesses in South Africa, which have been given until October 2023 to declare their beneficial ownership to the Companies and Intellectual Property Commission, CIPC. This follows concerns raised by the Financial Action Task Force over South Africa's failure in terms of financial crimes and anti-money laundering. Now, the FATF, whose recommendations the South African government is following, stated that sanctions should be applied to companies that breach their beneficial ownership obligations. According to Tax Consulting SA, the compliance burden ultimately rests on shareholders, directors, and owners of companies who will need to comply with the CIPC's new requirements. Joining me now is Micaela Paschini, attorney at Tax Consulting SA. Micaela, welcome to Business Edge. Thank you so much for joining me.
Thank you so much for having me.
So when we look at the beneficial ownership conversation in South Africa and also where the Financial Action Task Force has really highlighted it, what's the need for this amended requirements? How has South Africa addressed the issue of beneficial ownership before now?
So I think it's important to really understand the background behind the introduction of these new laws. Basically, what happened is that the Financial Action Task Force, or the FATF, conducted an investigation into South Africa's measures in place to combat money laundering and terrorist financing. And one of the items they noted is that South African lawmakers or law enforcement does not have proper access to timely and accurate beneficial ownership information in respect of both trusts and companies. So as a result, South African lawmakers have now introduced these new requirements following the recommendations by the Financial Action Task Force. So the new legislation actually does not only extend to companies, but also to trusts. So we have seen that there has been an implementation of measures to really address the issues.
All right, so we'll get to who is going to fall under this. But one other point that we probably need to ask for our audience is this issue of transparency and accountability, or this issue of having ownership shrouded in some form of mystery. Why is it something that the FATF flagged in terms of possible linkages to financial crimes and money laundering?
So I think the South African lawmakers noted that there is this gap where it's not always possible to trace the funds or follow who actually is in charge or who owns a business. So previously, it was not necessarily a requirement for shareholders to be recorded as such on the company's registers. But now with these new amendments, the beneficial ownership information will need to be registered with the CIPC, and other lawmakers may have access to this information. So the CIPC has also indicated that SARS may have access to the information, which is our revenue authority, as well as the Financial Sector Conduct Authority. So it does really remain to be seen what is going to be done with this information and who truly will have access. Because I think, as you can imagine, shareholders might also be nervous about their information being registered with the authorities as such.
Okay, so let's talk about who falls under this new requirement. Who is considered a person with beneficial ownership in a company? What's the percentage which would be required for such an individual or a group of individuals before they're obligated to submit this needed information to the CIPC?
So a beneficial owner is basically the warm body behind the shareholding in a company, and all companies and closed corporations in South Africa are required to make sure that their beneficial ownership information is registered with the CIPC. There are one or two exemptions, but generally all companies must comply with this.
So you mentioned the issue of trust earlier, and so I want us to look at that. In the past, we've seen shadow ownership schemes involving trust. Does this further complicate the filing process, or are there some special provisions in place for this? And in terms of these trusts, what are the entities? How would they be affected when it comes to this situation, this requirement in particular?
I think a lot of companies were previously or still currently are owned by, for example, a trust or a shell company, but it's not exactly clear who actually owns and funds the business on a day-to-day basis. So when it comes to this new beneficial information being recorded, the details of that person behind the trust would essentially be placed on record. And this, we presume, may also enable entities such as SARS to really compare the information registered with the CIPC with information submitted to them and truly determine whether all shareholders are making accurate declarations to SARS, and also where there is money flowing in and out of South Africa, whether proper processes are being followed with regards to exchange control.
All right. So in terms of the requirements for this, what implications do you think it will have for a shareholder who probably has a stake in a South African company but resides outside of the country where the company operates? In trust, or basically the impact do you see that this could have on foreign business owners who have businesses in South Africa?
I think there are quite a few impacts we need to consider here. Where an entity or where a company, a South African company, is non-compliant, it may face administrative sanctions. It may also face fines and so forth.
Okay,
In addition to this, directors of, sorry?
No, go ahead, Micaela.
So directors of companies may even be disqualified from acting as directors. So it's also another consideration that we need to have a look at is when an entity is non-compliant, this will also now be made predominantly clear to law enforcers, as well as potential persons who the company needs to do business with. So the risk here is also that the company and the foreign shareholder may be prevented from doing further business in South Africa until such time that proper compliance is reached by the company.
Okay, so on the screen you can see 8 strategic deficiencies that that South Africa is meant to work on that came from the FATF's 67 recommended action points. In terms of addressing this beneficial ownership situation, how urgent and important is it for South Africa to get this right and also help it get off the grey list?
I think this needs to truly be prioritized by both South Africa and business owners as a whole. We have seen the grey listing that took place because of South Africa's non-compliance with beneficial ownership standards, and therefore our economy has also unfortunately suffered under this. So I think it's something that no one should take lightly because it is crucial to our country's well-being that proper access is available to beneficial ownership records, and also to prevent South Africa from becoming or from enabling money laundering and terrorist financing.
SA says at the end of the day, complying with this requirement falls on shareholders, directors, and the owners of companies. And you've mentioned a bit of the consequences. Just for reemphasis, I want us to look at those potential consequences again. And then I'll ask you in terms of, do you think it is consequential enough for South Africa to see companies immediately complying within the next 3 months to the timeline and the requirements coming from the CIPC?
So some of the criminal sanctions and civil sanctions that the CIPC has noted are the administrative fines that may be imposed on a company. Additionally, the company may be investigated by the CIPC and issued with a compliance order. So they have also indicated that sanctions will be applied, and the sanctions may even be severe. In terms of the effectiveness of the sanctions, it's truly difficult for me to comment on whether these sanctions or consequences will be effective, just because it is still very early days. The laws are still new, and we are not certain yet as to what measures will truly be taken to ensure that everyone complies.
All right. And Micaela, before I let you go, the positive side of this is one thing that South Africa must do to get off the gray list, but it's also something that can also have a positive benefit on the economy. So I think we should end with that point. In terms of what the benefit will be for South Africa's economy to have this beneficial ownership requirements enshrined and complied with, what do you think that is?
So I think it's something of an international standard in a lot of jurisdictions to have proper beneficial ownership information and access to such records. And I think South Africa, raising the bar to actually comply with international best practice would truly, I think, also foster investor confidence here and just really make them certain that South Africa is making an effort to comply with the international best practice standards.
All right, that is well noted. Micaela Paschini, attorney at Tax Consulting SA, will continue to follow up on this conversation, and when the deadline comes and even some of the feedback from business owners in South Africa around this requirement, we'll see what that is when we talk to you again. Thank you so much for joining me.
Thank you.